5, 4, 3, 2, 1, start. By way of the present petitions, question has been sought of the criminal complaint number 49 dated 24/1/2011, Annexure PA filed under sections 458, 427 and 149 of the IPC, read with section 120B IPC, pending in the Court of Learned Judicial Magistrate, First Class, Kethal, the summoning order dated 19 July 2011, Annexure P3 and the order 28 October 2014, Annexure P4, whereby the revision petition filed by the petitioners was dismissed by the Learned Additional Sessions Judge Kethal, along with all subsequent proceedings arising therefrom, qua the petitioners, full stop. Pithily, the complaint was filed by the respondent, who is brother of the tenant of a chemist shop situated within the premises of PGIMS Kethal, full stop. In the said complaint, the petitioners, who are officials working in the administrative office of the PGIMS Kethal as superintendent, assistant security officer and deputy medical superintendent, and the vice chancellor of the said institute, were arrayed as accused respondents, full stop, stanza. The allegations levelled therein are that 30 to 40 persons had tried to get the shop of the brother of respondent vacated, and all accused had taken away the medicines worth rupees 70 to 80 lakhs along with other medical equipments, full stop. It was also stated by the complainant that he had approached the vice chancellor, who refused to entertain his complaint, whereupon the complaint in question was filed by him before the trial court, full stop. The petitioners were summoned by the trial court by order dated 19/7/2011, Annexure P3, which was taken up in revision before the Additional Sessions Judge Kethal, and the same came to be dismissed by order dated 28 October 2014, Annexure P4, full stop. Learned counsel for the petitioners would contend that, as a matter of fact, on 4 June 2006, the license of R.K. Mittal, tenant of chemist shop, who is the brother of respondent complainant, was cancelled, which came to be challenged by him in a civil suit dated 16 July 2006, full stop. The trial court, by judgment and decree dated 23 May 2007, dismissed the same, full stop, stanza. The appeal filed before the Learned Additional District Judge also came to be dismissed by judgment dated 12 August 2008, full stop. Aggrieved tenant had thereafter filed RSA number 86 of 2012, challenging the judgments as passed by the courts below, which was also dismissed by this court by judgment dated 16 February 2011, Annexure P12, full stop. Learned counsel brought to the notice of this court that during the interregnum, the institute had also initiated the proceedings under sections 4 and 5 of the Haryana Public Premises and Land (Eviction and Rent Recovery Act) against the petitioners on 10 January 2008, wherein an order dated 6 March 2010 was passed by the said authority in favor of the institute for his eviction within 30 days, full stop. The said order was unsuccessfully challenged by him by way of filing an appeal, which was dismissed on 5 April 2010 by the Commissioner Kethal, full stop. The Vice Chancellor had also received legal advice dated 17 January 2011, Annexure P5, in the matter from the counsel representing the institute before the Learned Trial Court, wherein he had informed that the appeal filed by R.K. Mittal in respect of the chemist shop has been dismissed by the Learned Additional District Judge Kethal, and now the shop can be got vacated, full stop, stanza. It is only thereafter the office order dated 18 January 2011 was passed by the Institute of the Petitioners to take possession of the shop full stop. Whereafter a DDR was also recorded on 18 January 2011 Annexure P6 wherein it was mentioned that the possession of shop number 10 was taken had been got vacated in the presence of shopkeepers of the vicinity, SHO, Police Station, Urban Estate, Sri Ranjit, security officers of PGI in discharge of their duties to avoid any clash during taking out the proceedings full stop. Learned Counsel would contend that it was only after adopting due procedure including notice having been given that the possession had been taken of the shop in question which was in occupation of the brother of the respondent that too after he had lost the litigation up to learned District Judge Kethal whereby his appeal was dismissed on 17 January 2011 full stop. The tenant did not file any complaint but it is his brother who though had no concern with the business of the tenant, filed the complaint alleging that the items were stolen from the shop full stop stanza. Learned Counsel would further contend that besides the self-serving statement of the complainant, there being no independent corroboration thereto, the summoning order was erroneously passed by the trial court in a casual manner and without due application of mind full stop. It is also submitted that the factum of the petitioners discharging their official duties at the relevant time was not taken into consideration full stop. Learned Counsel has advanced threefold legal submissions, first limb of such being that the petitioners who are government officials working in PGIMS Cathal could not have been summoned by the trial court in absence of a prior sanction having been obtained under section 197 CRPC full stop senja. Insofar as the Vice Chancellor is concerned, he being appointed by the Governor of Haryana is a public servant within the meaning of section 21 IPC as per volume 1 University calendar and therefore prior sanction was required to prosecute him as well full stop. The second limb of submission being that the erstwhile tenant of the institute of the petitioner had got the complaint in question instituted with malafide at the hands of his brother to avoid payment of the necessary profit in as much as the civil litigation inter se the parties had culminated in favor of the said institute full stop. The third limb of the submission advanced by the learned counsel for the petitioner is that for institution of a complaint under section 156 CRPC, a prior complaint in writing had to be made to the police officials and in the eventuality of no action having been taken thereon either by the police officer concerned or his superior was a complaint under section 156 CRPC maintainable full stop. They further submit that in terms of the judgment of Supreme Court of India in the case of Reena and others versus State of MP and others, the complaint must also accompany a specific affidavit as to whether a complaint was submitted before the police authority, which in this case had not been so done, there also being no averment made in this regard full stop senja. Thus, the submission is that the magistrate in a casual and mechanical manner had passed the summoning order against the petitioners full stop. It was the submission of the learned counsel that the absence of prior sanction required under section 197 CRPC can be a ground for quashing of prosecution as no such sanction was obtained prior to issuance of summoning order full stop. Learned counsel would also contend that in case of the eviction on account of orders passed under the Haryana Public Premises and Land (eviction and Rent Recovery Act, no application for executing the said order is required to be filed as has been held by Honorable the Supreme Court full stop. Reliance was also placed by the learned counsel upon the judgment of Honorable the Supreme Court of India in the case of Insurance Company Limited versus New India Limited and another, wherein it was held that the Public Premises Act provide for a speedy remedy and the provisions of Code of Civil Procedure and the Evidence Act being not applicable, what is necessary to be complied with is the principle of natural justice full stop.